There are tons of different ways that you can hold title to a home. What holding title really means is how are you named and how does it work, right? Do you own it by yourself? Do you own it with someone else? Is it in a trust? So I'm going to go through all the different ways, at least in California, on how you can hold title to a home. First way you can hold title is sole ownership, right? So you're the only person that has ownership over this home. Nobody else has any legal right to the property at all. Now we have community property, which this is usually through marriage. I know California is a community property state, which basically means that both spouses have equal ownership in the property. There's another layer to community property, which is community property with right to survivorship. So what that means is if one of the spouse passes away, then the home automatically goes full 100% to the other spouse. So there's no probate, there's nothing that they need to go to. It just automatically, the shares in the house go directly to the other spouse. All right, so now we have joint tenants. Same thing, joint tenants with right to survivorship. So basically with joint tenants, it doesn't have to be a spouse, right? So it could be you bought a property with your brother and then you guys own equal share in that property. But let's say your brother passes away, you automatically get 100% of the property. It goes to you. So their share transfers back to you with the right of survivorship. Tenants in common. So it's very similar to joint tenancy, whereas you can have different people. It doesn't have to be a spouse. It could be a brother, sister, cousin, or business partners, where you have shares in a property, but they're not equal shares, or they don't have to be. I could own 10% of the property and you could own 90% of the property. The other thing about tenants in common is if I pass away and I have that 10%, instead of that 10% going to you, which that's how it would be if it was community or if it was joint tenants, it actually goes to my heirs. So if I have a son or a daughter, that 10% goes to them instead of transferring back over to you. That is your tenants in common. Trusts are very common in real estate, and mainly because it allows you to, when you put a property into a trust, or you could put multiple properties into a trust, I wouldn't recommend it though, or whatever assets you put in the trust, you put them in there in order for it to be able to be passed down to your beneficiary. So you also have the ability to determine what they do with that property when it's in the trust. They basically are beneficiaries of the trust. You're the manager of the trust. You could decide how much income they're going to take from it, whether they can sell it or whatever they can do. It has to be through the trust. Big reason people like it is because when that property does pass down to the beneficiaries of the trust, there's not a taxable event that takes place. So they're not going to raise your taxes. They're not going to hit you with a bunch of income taxes or capital gains or anything like that when you have the property in a trust. So you always want to talk to your attorney or a trust advisor whenever you're going to purchase a property, just so that you can make sure that it's the right thing for you. The last way that you can own a property is in an LLC. The main reason that you want to put a property into an LLC is, let's say myself and you, we buy a property together, you get divorced, and now you have your ex-spouse is going after everything you have. When the property's in the LLC, they can't touch that LLC. You're not having to, you may still have to liquidate your portions to pay, or your percentage in of the LLC to be able to pay alimony or child support, whatever it is, but it doesn't mean that we have to sell this entire property. We could basically just buy you out of the LLC if you need to liquidate your shares in it. So it's also important if you get sued, right? If you get sued personally, then they can't go after that LLC. Or if the LLC gets sued and the home is owned by the LLC, then it protects you personally. So if somebody trips and falls on the property, they're going to sue that LLC, and then you're protected from a personal standpoint. You'll want to talk to your attorney about this. Make sure this is the best way to go. You can also talk to your accountant, and they can help you decide, based on my current situation, what is the best way that I should buy this property, or should I move it into a trust? Should I move it into an LLC? One big thing you have to consider is if you are trying to move a property into an LLC and you have a loan on it, you have to notify the lender, because they have a decision in that. They get to be part of that decision because it could be more risky for a lender. If you owe a ton of money on it and the home is now underwater, they may want to be able to come after you. Always check with your CPA or your attorney and figure out which option is the best one for you.